Welcome back to Employment and Labor Law, Legal 267. My name is Scott Haddock. We're at Edmonds College's ABA-approved paralegal program, and you are on the fourth of 4 lectures for this week. So congratulations for making it through. Now imagine you're working in an employment law office, and a new client comes in with this story. They applied for 87 jobs. Every rejection came within minutes. No interview, no explanation, no human contact. Then they found out the employer used an automated screening tool that scored applicants before anyone in HR saw the file. Now imagine a different client. They were working remotely using a company laptop and later learned the employer was capturing screenshots, measuring idle time, tracking keystrokes, and using the data to support discipline. Or another client, they were denied a job after a cannabis test, even though the use was off-duty, away from work, and before they were ever hired. That's the workplace we're dealing with today in these times. So this final lecture for week 6 is a little different because we're moving into emerging workplace regulations. These issues don't always fit neatly into one statute or one familiar category. Artificial intelligence, privacy, cannabis, social media, monitoring, gig work, productivity quotas, federal contractor rules, and local ordinances. They all overlap with employment discrimination, retaliation, disability law, wage and hour law, labor law, and public sector constitutional limits. So we're not going to treat this as a random list of modern problems. Instead, what we're going to do is organize it into clusters. And the central idea is this. Washington state employment law is already broad enough to reach many modern workplace tools, even when the legislature has not yet created a specific technology statute. And that's the point I want you to carry through this lecture. A missing artificial intelligence, AI statute, doesn't mean a missing legal claim. A missing cannabis policy doesn't mean the employer can do whatever it wants. A vendor tool does not erase the employer's legal obligations. And this is where paralegals, again, are extremely useful. Someone has to understand the system, the policy, the timeline, the data source, the vendor records, the decision process, and the actual human impact. And very often, that person is you, the paralegal working under attorney supervision. So as we move through these issues, I want you to focus on 5 practical questions. Are you ready? What law applies? What system was used? Who made the decision? What records exist? And finally, what needs to be preserved? Those 5 questions will guide you well through this lecture. Let's get started. Modern workplaces produce an astonishing amount of data. A traditional personnel file might include an application, performance reviews, discipline records, leave forms, maybe a few emails. That file still exists, but it's no longer the whole story. Now the employment file may also include badge swipes, login records, GPS data, call logs, productivity dashboards, automated scores, Teams messages, Slack threads, screenshots, data customer ratings, route efficiency reports, and vendor-generated rankings. That data can help an employer manage operations, and it can also create a lot of legal risk. Employment law was not originally built, obviously, around AI resume scanners, webcam monitoring, automated discipline systems, or productivity dashboards that update constantly. But those tools still operate inside existing law. The Washington Law Against Discrimination, the WLAD, still applies. The ADA still applies. Washington's privacy protections still apply. Wage and hour laws still apply, and retaliation law still applies. And that's the first practical lesson this week. New tools do not erase old obligations. For paralegals, this changes the evidence map. The file is not just in HR anymore. It may be in payroll software, applicant tracking systems, vendor portals, device management tools, security logs, scheduling software, or messaging platforms. So when an employment case involves technology, one of the most important paralegal skills is knowing where the evidence lives. And that's not just a tech skill. That's a legal practice skill. If you don't know what systems exist, you may miss the records that explain why the employment decision happened in the first place. Let's begin with hiring and screening because that's where many modern employment problems begin. Washington State has become increasingly active in regulating what employers can ask, require, and consider during hiring. The Fair Chance Act limits how employers use criminal history early in the process. The policy is straightforward. People should not be screened out before they have a meaningful chance to be considered for the job. Washington also restricts driver's license requirements in job postings and applications unless driving is actually job related. That may sound small, but it can be very significant. A driver's license requirement can screen out applicants who do not drive because of disability, cost, immigration issues, or access to transportation, even when the job itself doesn't require driving. Washington also changed cannabis hiring rules. Under RCW 49.44.240, employers generally may not discriminate in initial hiring based on off-duty cannabis use away from the workplace, subject to important exceptions, including safety-sensitive positions and federal law conflicts. Now let's add AI screening. An automated hiring tool may look neutral because it treats everyone the same on the surface, right? But it disproportionately screens out applicants based on disability, age, race, sex, national origin, or other protected classes in many cases. And so the legal risk remains. The WAC, the Washington Administrative Code, 162-12-140, is also very important. Washington employers must focus on whether the applicant can perform the essential job functions, and that's with or without reasonable accommodations, rather than asking broad disability questions before a conditional offer. So that at the hiring stage, it's no longer just an application and an interview. In Washington State, it's a legal risk zone. And for paralegals, hiring records are not just resumes and interview notes. As you can imagine, they may include job posting language, screening criteria, automated rejection reports, accommodation instructions, vendor records, chatbot transcripts, scoring rubrics, and internal explanations for why applicants were moved forward or screened out. The paralegal move is to connect the tool to the decision. Do not stop at the applicant was rejected. Find out how the rejection happened. Here's a clean rule to get us started on this next slide. The algorithm is not a legal defense. Washington State does not currently have a comprehensive AI employment statute, at least not yet. But existing law still applies. The WLAD prohibits discrimination in hiring, promotion, discharge, and other employment decisions. So if an AI tool produces discriminatory results, the employer may still face liability under existing law. A very useful Washington State case for this framework is Arroyo versus Pacific Maritime Association, decided in 2023 by the Washington Court of Appeals. Arroyo was not an artificial intelligence case. Let me just say that flat out. But it involved a longshore hiring system and allegations that specific employment practices disproportionately affected Latino applicants. But this case gives us a useful modern Washington framework for disparate impact analysis under the WLAD. In Arroyo, the court emphasized two core requirements. First, the plaintiff must identify a specific employment practice. And second, the plaintiff must support the claim with statistical evidence showing a substantial disproportionate impact on a protected group. That framework translates well into AI screening disputes. The software may be new, but the discrimination analysis is not new. If an automated tool rejects older applicants or disabled applicants or Latino or women applicants or applicants from another protected group at statistically disproportionate rates, Arroyo gives us a way to analyze the problem under Washington law. Employers should be asking, what does the tool measure? Was it validated? Were results audited? Is human review even possible? Can applicants challenge errors? And are accommodations built into the process? Did anyone check whether the tool produced protected class disparities? And if no one can explain the tool, well, that's not reassuring. Write this down. A vendor tool can become the employer's evidence problem. I'll repeat that. A vendor tool can become the employer's evidence problem. And for paralegals, this means you do not just print the final score and move on. You ask what generated the score, what data went into it, what criteria were weighed, whether anyone reviewed the result, and whether exceptions were possible. That's how you turn a mysterious automated decision into an evidence record. Now, artificial intelligence, AI, creates a particular risk for disability discrimination. In your reading, Chapter 10 discusses federal guidance warning that software, algorithms, and AI tools can violate the ADA if they screen out qualified people with disabilities or if they force applicants to disclose disability-related information. Think about video interview scoring. A tool might score eye contact, facial expression, speech speed, tone of voice, pauses, or body movement. And those markers may have nothing to do with whether the applicant can perform the actual job. Think about timed online tests. A timed test may disadvantage an applicant who needs additional time because of a disability. And think about chatbots or hiring portals that are not accessible to screen readers. The employer may say, we use the same tool for everyone, but that's not enough. Equal use of a flawed tool can still create unequal impact. The practical safeguard is human review, accommodation access, audit trails, and clear applicant instructions. Applicants need a meaningful way to request accommodation or an alternative process. And for paralegals, the records to look for include the vendor materials, scoring criteria, accommodation notices, applicant instructions, exception logs, internal emails, and communications showing how accommodation requests were handled. And here is the practical litigation point. If a company cannot explain how an applicant was screened out, that may become a problem even before anyone proves the tool was biased. This is where disability law and technology law butt heads. They're not separate topics anymore. They're now part of the same employment file. Washington State has strong privacy traditions, very strong. Article 1, Section 7, Washington's Constitutional Privacy Clause, protects private affairs from disturbance without authority of law. The constitutional provision is especially important in public sector and government action contexts. Meanwhile, Washington's Privacy Act, located at RCW 9-73.030, generally requires all-party consent before recording private conversations, subject to some exceptions. That becomes very important in workplaces. Employers may monitor work systems, but the legal analysis depends on the type of monitoring, the notice that was given, the scope of the consent, the setting, and how the employer uses that information. Now, remote work adds another layer. A company laptop in a home office is still company equipment, but the home environment may include private spaces, family conversations, personal devices, and non-work activity. Keystroke monitoring, webcam monitoring, screenshot capture, audio recording, GPS tracking, and productivity tools are not all the same. So for paralegals, don't write the employee was monitored and leave it there. That's just too vague. Instead, identify what was monitored. Was it audio, video, metadata, location, browser activity, screen captures, keystrokes? Was monitoring constant or was it limited? And was the employee notified? And did the employee consent? And did discipline rely on that data? It's easy to install. Easy to install does not mean lawful to use. So just because software is easy to get doesn't mean it's lawful. Technology vendors will sell employers tools that can do almost anything. Employment law asks a different question. What was the employer legally allowed to do with that tool? Two Washington state examples help make the privacy issue more concrete. First, Smith versus Employment Security Department, decided by the Washington Court of Appeals in 2010. That case involved workplace recording issues and Washington's Privacy Act. And the practical lesson is that recording workplace conversations in Washington should not be treated casually. All party consent rules can create serious legal problems. The second case is called Matter of Cantor. It's a Washington Court of Appeals case from 2025. Matter of Cantor involved constant internet monitoring software. Can you imagine? It was not an employment case, so we don't treat it as a direct employment rule, but it is a useful analogy for how courts may think about invasive digital monitoring. And the broad lesson is simple. Technology makes monitoring easy, but ease is not the same as legality. For paralegals, privacy cases require precision. Again, was it audio, video, metadata, keystrokes, browser activity, location tracking, biometric data, or screen capture? Those distinctions are not technical trivia. They may affect the legal theory, the defenses, the admissibility issues, the damages, and the settlement value. So if an attorney asks what was monitored and the answer is everything, that's just not good enough. Everything is not useful evidence category. A strong paralegal answer sounds more like this. The employer captured screenshots every 5 minutes, tracked active and idle time, logged URLs, and did not record audio. That level of precision helps the attorney evaluate the case. Let's switch gears and talk about cannabis law and drug testing. Washington state cannabis law is a good example of how state and federal employment law can fit together rather awkwardly. Washington generally protects applicants from discrimination in initial hiring based on off-duty cannabis use away from the workplace. That protection appears in RCW 49.44.240. But that does not mean employees may be impaired at work. It also does not eliminate safety-sensitive exceptions or federal law conflicts. Employers can still regulate workplace impairment. They can still maintain certain drug-free workplace rules. They can still comply with federal requirements. Now, Chapter 10 also gives us the ADA baseline. Current illegal drug use is not protected under the ADA. Former users or recovering users may be protected, depending on the facts. Drug tests themselves are generally not treated as medical exams under the ADA. So the analysis is not simply, can the employer test someone for drugs? The better legal analysis is more specific. At what stage did the testing occur? What substance was tested for? What job was involved? And was that position safety sensitive? Was the employer responding to actual impairment or only to a historical positive test? Was federal law implicated? And was the policy applied consistently? That's where the legal work happens. A sloppy policy that treats every cannabis result the same way can create avoidable risk. And so for paralegals, separate hiring stage issues from workplace impairment issues. They're related, but they're not the same legal question. And that distinction will keep your analysis cleaner and much, much more useful. Now let's talk about public sector drug testing. Public sector drug testing adds yet another layer because public employers are government actors. That means constitutional search and seizure principles may enter the picture. Chapter 10 discusses this because public employment can raise Fourth Amendment issues. Private employers usually don't face the same constitutional limits, although statutes, contracts, policies, and common law claims may still apply. But for public employers, the analysis may involve the employee's privacy expectations, the nature of the job, whether the position is safety sensitive, whether testing was random or suspicion-based, and whether the policy was narrowly designed. Think about transit operators, law enforcement, corrections, medical roles, heavy equipment operators, or certain school employees in safety-sensitive roles. The public employer's safety interest may be strong, but the policy still needs to be carefully designed and consistently followed. For paralegals, the records are central. Collect the policy, employee notice, consent forms, test results, chain of custody documents, job description, safety rationale, prior enforcement history, and any communications explaining why the testing occurred in the first place. Again, the paperwork is not just background, it's the whole case. And for public employers, the policy record is especially important because the issue isn't only what the employer wanted to do, the issue is also whether the government employer used a lawful procedure. Chapter 11 of your textbook includes guns at work laws. Now, Washington state is not the strongest example compared to some states that have detailed parking lot firearm statutes. But the topic is still useful because it brings together workplace safety, policy drafting, discipline, and public-private employer distinctions. Employers may want strict rules against weapons at work. Employees may raise lawful possession, vehicle storage, public employment, or state law arguments depending on the jurisdiction and the facts. But for our purposes, the key skill here is issue spotting. If a discipline case involves a firearm, do not treat it only as a conduct issue. Ask what policy applied, and was the policy clearly communicated? Was the employer public or private? Was the weapon on the person, in a vehicle, or in a restricted area? Was there a threat? Was discipline consistent? And were other employees treated the same way? Workplace safety issues often overlap with disability, retaliation, union rights, privacy, and public employer rules. That's the modern employment law theme again, overlapping systems. As a practical matter, workplace safety policies need precision. A vague weapons policy is almost guaranteed to create problems when enforcement becomes necessary. For paralegals, the policy language and the facts of possession are both extremely important. You need the policy, the incident report, witness statements, location details, prior disciplinary history, and any safety communications. And this is where good factual timelines can make the attorney's job much easier. Now let's move over to social media, and specifically social media investigations, because social media investigations are now routine in employment practice. Employers discipline employees for posts about coworkers, politics, protests, customers, workplace conditions, and conduct outside of work. But not every embarrassing post is legally simple. Public employees may have speech protections. Private employees may have rights under labor law if they're discussing working conditions with coworkers. And Washington State also has social media account privacy protections under RCW 49.44.205. That statute restricts employer access to personal social networking accounts. Again, that's at RCW 49.44.205. So when an employer says, "We fired the employee because of social media," the next step is not to react emotionally to the post. The next step is to build the legal record. What exactly did that post say, and who saw it? How did the employer get it? Was it public? Was it private? Did it involve wages, schedules, workload, staffing, safety, discrimination, or other workplace conditions? And did the employer ask for access to a personal account? A screenshot alone may not be enough. Screenshots need context, authentication, date information, and sometimes more metadata. Paralegals may help preserve posts, capture surrounding context, compare policy language, identify who accessed the content, and organize the timeline. But just remember, social media is evidence, but it is not self-explaining evidence. And this is a good place to preview labor law. Posts about wages, schedules, workload, staffing, or safety may involve protected, concerted activity, a phrase that you're going to hear a lot in the last few weeks of this course when we go into labor law. Even if the employer finds the post irritating, it may involve concerted activity that's protected. Irritating is not the same thing as unprotected. So the practical move is not to ask whether the employer liked the post. The practical move is to ask whether the post triggered protected rights, violated a lawful policy, or created a legitimate workplace concern. Now let's switch gears and talk about Washington State's warehouse quota law. That law is located at RCW Title 49, Chapter 84. And it's one of the clearest Washington examples of regulation aimed at algorithmic productivity pressure. Many employers now use software to measure speed, output, idle time, scans per hour, deliveries per route, calls per shift, tasks completed, or time between assignments. And that data can affect discipline, pay, scheduling, promotion, or even termination. But productivity systems can create legal issues if they interfere with breaks, if they create safety risks, if they penalize protected leave, or if they ignore accommodations or produce discriminatory effects. A productivity score may look objective, but the legal question is what the system actually is measuring. Does it account for disability accommodations? What about for legally required rest and meal breaks? Does it penalize employees who use protected leave? And does it apply consistently across the departments? Does it allow for human review? And does it punish people for time the law protects? This is where employment law is moving. The issue is not only whether a supervisor was biased. The issue may be whether the system itself pushed unlawful outcomes. That's a more sophisticated way to think about employment law, and it's exactly the kind of thinking modern paralegals need in employment law practice. So as a paralegal, don't treat productivity data as self-explanatory. Ask how the quota was set, what exceptions existed, whether breaks were protected, whether accommodations were entered into the system, and whether discipline followed automatically or after human review. The spreadsheet may look neutral. Your job is to help the legal team understand whether it really was neutral. Worker classification. Now, worker classification remains a major employment issue. Gig work, Think DoorDash or Uber. And app-based platforms have blurred the line between employee and independent contractors. Classification affects wages, benefits, leave, unemployment, workers' compensation, discrimination protections, and organizing rights. Washington state and local jurisdictions, especially in Seattle, have been active in regulating some non-traditional work arrangements. As paralegals, the key is to look for control. Who sets the rates? Who controls the schedule? Who disciplines workers? Who controls access to the platform? Can the worker reject assignments? Who owns the customer relationship? And what data does the company track? Who can deactivate the worker? Digital platforms create huge evidence trails. App logs, ratings, deactivation notices, route data, customer complaints, algorithmic assignment records, payment histories, and message records may all become extremely important in your case. Worker classification isn't just a label in a contract. If the economic reality and actual control point is in a different direction, the label may not carry the day. For paralegals, don't underestimate the importance of organizing platform records. In gig work cases, the app may be the closest thing to a supervisor's file. And that's the practical point in this slide. In gig work cases, the app may be the workplace file. So a final few topics connect this week to where we're going next in the course. Washington's Free Choice Act and captive audience restrictions connect employment law to labor organizing and employer speech. We'll move more deeply into labor law in the coming weeks, but for now, remember that mandatory workplace meetings about political, religious, or union-related issues may raise legal concerns. Washington has also seen developments involving unemployment benefits during strikes or lockouts, which connects to labor relations and collective action. Chapter 11 also covers the USERRA. That stands for the Uniformed Services Employment and Reemployment Rights Act of 1994. That's a federal law that protects civilian job rights and benefits for veterans and members of the uniformed services, and it includes National Guard and Reserve. It ensures service members can return to their civilian jobs. They're not discriminated against, and they can maintain benefits. The USERRA includes reemployment rights, benefits protections, and anti-discrimination rules. Washington also separately protects veteran and military status under state law. Finally, federal contractor and DEI, diversity, equity, and inclusion rules, are in a period of instability, as you might know. Chapter 11 discusses Executive Order 11246 by President Donald Trump, and later executive order developments affecting federal contractors and DEI programs. The practical point this week is not to memorize every executive order or every law. The practical point is that multi-state employers and federal contractors need current legal review before changing equal employment opportunity, affirmative action, or any DEI policies. This area moves quickly. And when law moves quickly, paralegals help by tracking documents, dates, policy versions, agency guidance, court orders, and source authority. That work may not look dramatic, but it can be incredibly valuable. This slide also starts moving us towards the final part of the course, where we shift more fully into collective rights, labor relations, organizing, bargaining, and workplace power. Emerging workplace issues create a strong role for paralegals. You may help audit hiring forms, review policy language, organize monitoring records, track legal updates, compare local and state requirements, preserve social media evidence, index AI vendor materials, or build timelines from digital systems. But emerging law requires humility. If the law is unsettled, do not overstate the conclusion. Flag the issue. Identify the authority. Organize the facts and bring it to the attorney. That is professional legal work. The paralegal doesn't need to be the final legal decision maker to be extremely valuable. In fact, one of the most valuable paralegal skills is knowing when the file contains legal risk that needs attorney review. In modern employment law practice, those risks may be hiding in software settings, vendor contracts, application forms, monitoring tools, cannabis policies, social media screenshots, warehouse quota systems, or local ordinance requirements. So yes, the workplace is getting more complicated. That's also why skilled paralegals are needed now more than ever. The goal is not to know every answer instantly. The goal is to recognize the issue, preserve the record, and help the attorney analyze it accurately. That's exactly the kind of judgment this course is trying to build. All right, you finally made it to the last slide, and let's close week 6 once and for all. The textbook gave you the federal baseline for disability discrimination and other employment legislation. The lectures added the Washington practice layer. Now this week we saw that employment law is not just a collection of separate statutes. It's about how employers make decisions, how employees experience those decisions, and how records reveal what actually happened. Disability law connects to accommodation, leave, privacy, artificial intelligence, performance, and retaliation. Emerging workplace regulation connects to cannabis, screening, surveillance, social media, productivity tools, worker classification, public sector rules, and local ordinances. And throughout all of this, Washington law often provides broader or different protections than the federal law. Now, next week, we're going to shift into workplace safety and regulatory issues. That means we'll look more directly at how employment law operates when workplace conditions, safety duties, inspections, injuries, public regulation, and compliance systems all merge and come into play. That's the natural next step because many of the issues from this week, the monitoring, drug testing, accommodation, the privacy, the discipline, and documentation, they all often appear inside safety and regulatory systems. So as you finish this week, I want you to carry forward one practical habit. When an employer gives an explanation, ask what facts, records, and procedures support it. After that, we'll spend the final part of the course moving more deeply into labor law, collective rights, organizing, bargaining, and workplace power. Keep taking careful notes, keep building practical judgment, and keep thinking like paralegals who will one day help real clients navigate real workplace problems.